Good evening. I'd like to welcome you to Town of Reddington Shores Board of Commissioners special meeting. It's Wednesday, September 25th, 2013 at 7 p.m. Please rise for a pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Patty, call the roll, please.
Commissioner Catlin?
Here.
Vice Mayor Branch?
Here.
Mayor Adams?
Here.
City Denhart?
Here.
This time I'd like to open the public hearing.
Let me go ahead and read the title first, if that's all right.
Yes, sir.
In fact, I'll read the whole ordinance again. Ordinance number 13-05, an ordinance approving and adopting a development agreement with La Vistana 2 LLC relating to the development of property generally located at 17730 Gulf Boulevard, Redding Shores, Florida 33708, authorizing the mayor to execute the agreement, providing an effective date. The town of Redding Shores does ordain, Section 1, the development agreement between the town of Redding Shores and La Vistana 2 LLC, a copy of which is attached hereto and incorporated herein as Exhibit A, is hereby approved and adopted subject to the requirements of Section 2 below. Section 2, the mayor is authorized to execute the development agreement on behalf of the town immediately upon, but not until, the developer has provided to the town all the requirements of the development agreement pertaining to such matters as title insurance, transfer of deeds, including the deed of easement, providing satisfactory insurance as required by the developer's agreement, and any required escrow of funds with the town, and all such items have been approved by the town attorney. Section 3, the development agreement shall be valid for a period of 30 years from the date of execution. Section 4, this ordinance shall take effect immediately upon its final passage.
I would like to make a motion that we...
Hold on. Hold on.
Yeah, before you make a motion to be proper, have a public hearing, and I guess at this time, anybody that's going to give testimony, please stand, and the deputy clerk will administer the oath. The attorneys, you don't have to be sworn in because your testimony is not testimony anyway, but anybody else, if you think you might speak in the hearing, please take the oath.
Please raise your right hand. Do you solemnly swear or affirm that anything you will say will be the truth, the whole truth, and nothing but the truth?
I do.
All right. I'd like to open the public hearing and call on our building official, Steve Andrews.
Yeah, to recap, the Planning and Zoning Board offered this project board for approval, the development order and site plan based on the staff report where I referenced the previous approved PUD with the La Vistana 1 and 2 and wanted to offer in the record that the entire file of the town for La Vistana 1, La Vistana 2, and all documents.
So you're asking to introduce into evidence the town's files on the development going back to La Vistana 1 and 2?
Yes, that's all of what a lot of the report is based on. They recommended approval and
That would be fine, and you can accept that.
Yeah, I accept that into records. Thank you.
Any proponent?
Yeah,
Or
any
anybody
pro-
wish to say anything?
Does the developer wish to say anything and then listen to the opponent?
Okay. My name's Robert Lyons. My address is 20,001 Gulf Boulevard, Indian Shores. I've been hired by Mr. Jeffrey Miller, the manager of La Vistana LLC 2, to assist him in bringing this project to fruition and to request an amendment to the existing PUD that's on file here at the town. He purchased the property, has negotiated an agreement with La Vistana 1 to separate it from in a existing condominium that had been there for several years. and then work to redesign the approved building and site plan of the PUD to bring forth this amendment to the board and the town. We appreciate y'all's time and working with us, and the attorney, the building official, and all the effort that's been put into getting to this point. I'd like to tell you a little bit about the project. I was involved in it back in the very beginning when the Sunshine Hotel was there, and we purchased that property, had it designed, received approval to construct the original building there, and during, we received the permit, started work, and subsequently acquired the piece of property to the right-hand side, or to the north side, that today is Lavastana B, or is, that we're asking to amend that. And so when we acquired that property, we requested that the city allow us to design it as a part of Lavastana A, and the proper way to do that was through a PUD. And so we, with the town attorney and building officials' help, brought that through to approval with the commission, and increased the level of that building by one level. We designed 14 units on the north side, as opposed to today we're requesting 7. We also agreed to construct 2 commercial buildings on the road as a part of that PUD. Those are separate parcels that are called out in the site plan. We donated to the city a lot that's located down the road in front of La Contessa and in another city, actually, another Reddington. And we agreed to do lots of landscaping and other items that we negotiated as additional above and beyond the required code to obtain that right. So we started that building. We received a building permit, started it, put in the pile foundation. The economy did what all of us know it did. It went down severely, and the project was stopped. It was subsequently acquired by the bank that had a loan on it, and Mr. Miller has purchased it from that bank. When he did that, there was an existing condominium association that included 14 units in law. They were not there in reality in structure, but they were there in law. And so he sat down with his attorneys and with the association and their attorneys and came to an agreement of a way to separate those 2 parcels of land. It's extremely difficult in our state to do that. And one of the requirements is that you have to have a minimum of 80% of the people of the condominium vote to make that change. And so they acquired that 80% through lots of effort and separated the 2. Part of that agreement that's in place today that allowed that to happen was that the bank would make a significant, about $250,000 contribution to the association, which they've enjoyed for the last I don't know how many months, 6 or 8 months. And they also agreed, Mr. Miller agreed to construct a bathroom out on the Gulf side behind the new building. He agreed to share in the expense and cost and use of the existing swimming pool and spas. He agreed to allow the existing parking that's between the commercial parcels and the front of the condominiums to be utilized by both condominiums. And then he's increasing the surface parking significantly between the front of the new building and where those commercial parcels are located. And those areas will be used by both condominiums as well. So on the beach, I'm sure y'all living out here know that parking is at a premium on any of these condominium associations, and so that additional parking is a great benefit, I believe, to both. And so everybody seemed to be happy. There had been no objections for a number of months. I'm not sure how long that agreement's been in place, but it's, I believe, been more than 6 months that it's been in place. I think it's closer to 9. let's see here. There was a citizen at the last meeting that was concerned about elevations, and he thought that we had built the land up. It has not been. It's at the proper elevation. It's at the elevation it was originally purchased at. We believe that there aren't any variances required because I was a part of putting into place a PUD for this city and negotiated with the county, Pinellas County Planning Council, brought them in, and they worked with y'all's commission to write an ordinance for the town that didn't exist at that point in time for the PUD. And my understanding and the way that I've worked with PUDs in the past in other towns and this one is that you can negotiate just about anything within the boundaries of that property when it's zoned PUD, other than density. Density is something that we can't negotiate between us as to the developer and the commission, and so height is not a, you don't need a variance to height, you don't need a variance to side setbacks or parking quantity or any of the things that are in the code, because this is an ordinance and a code on its own. And so we negotiate those items, and we appreciate the town's professionals working with us to get that to the place we are today. Mr. Miller has agreed to provide the 2 commercial parcels that are shown out in the front there, to donate those to the city for the purpose of building parks in those 2 spots in lieu of constructing commercial buildings. He doesn't believe that those buildings will be a benefit, nor do the people in La Vistana A. They did not want those buildings there. They had concern about traffic and parking and the public being in and out because they have to park behind those buildings. And I believe that was a part of the separation agreement, that he would attempt to do that. He doesn't, it's not a requirement, but he agreed to attempt to eliminate those. And he's also agreed to provide the city $50,000 toward the construction of those park lands. Toward walkways or benches or vegetation, irrigation, those kind of things. We don't believe it'll take more than that to do them both, depending on, how the design of that is completed. The maintenance also of those properties, he didn't want that to be a burden on the city, so he's agreed to write it into the documents of the second condominium that they'll maintain those areas for the town, the vegetation, mowing, that kind of stuff. The original approved height of this building, which was 14 units initially, was at 85 feet above the crown of the road, and Mr. Miller would like to request that we go to 92 feet above the road. These units are larger than what was originally proposed, and he believes from a marketing perspective that would benefit the project. I've got a rendering here that I'd like to introduce, if I can put my hands on it. I can introduce that into evidence. I'm not sure how to go about doing that, but this is the building A, and this is the proposed building B.
And from last time, this spatial is to match to this, right?
Yes, sir, exactly. Yep.
I'll accept the rendering and evidence.
Thank you. We have a site plan here that I'd like to introduce into evidence as well. And I have some small ones and some large ones here. Let me find the correct one to give you. Those,
I'll accept these into evidence. also.
thank you. Those, this drawing is identical to those other than the color, but we wanted to show the commission the difference in the view corridor between the two buildings. There are concerned citizens in the building next door that believe that there's additional, that they're losing view corridor from what's already been approved. And so Hoosh with Northside Engineering put together this plan for us, and we've indicated this area is the protrusion of the existing approved plan, and this is the additional view that this person will get from the corner of their unit, and this area is the additional view that there's a balcony here and other balconies all the way down. The existing approved plan comes to this point, so from here to here, this stack units, if the original plan were built, would lose all of their north view. They're gaining all of that, plus from here back, they're gaining that direction of the intercoastal waterway and the road. And, view is very important on the beach. I know that's what most people want to live here for, that and the water. And so wanted to show the difference there. This is a little simpler plan that shows this is the building that is proposed today in yellow, and the gray area is the existing approved condominium as the PUD sets this evening.
Just for the purpose of the record, I marked your rendering as A1.
Okay.
Applicants number 1.
Okay.
And I marked this as A2 for applicants number 2.
Okay.
And I don't know whether you were introducing
Yes,
these ones or not.
Yep, I would like to, please.
Then we'll call them A3 and A4,
Okay,
the two you just talked about.
thank you.
And I don't know whether those other ones are yours or somebody else's.
Actually, I think those belong to the town, or we've left them here in the past, so. We also, with regard to view, I don't have a large one of these, but one of the residents next door was concerned about view going vertical, and so Northside Engineering put together a comparison for us. The red dotted line represents the existing approved structure and its elevation, and the blue view corridor from the little person there represents the difference in the view of the sky that would be lost with additional elevation of the new building that Mr. Miller is requesting. If I could introduce that into evidence, I would appreciate it as well.
Then this would be A5.
Yes, sir. Okay.
It's accepted also.
And that's titled, what, site, a skyline of sight from balcony.
Yeah. And this is another elevation that we did that shows the difference between the two buildings. If you were standing at the south property line and looking toward the north, the green area represents the roof above, as it will be approved this evening if you see fit, and the red portion, the lines and the balconies, represent what's approved already today in the PUD. I would request that this drawing be submitted into evidence as well.
And there'll be A6 if you desire.
A6, yeah.
And what
We'll
are
accept.
This one doesn't have a title.
Then
the side of the frontage, right?
Yes, yeah, correct.
North side view of proposed new building.
Yes, sir. There was a citizen at a prior meeting that was concerned about drainage, and, this will be an improvement to the drainage as it exists today. But in either form, what's approved today or what is proposed will retain all the runoff from our site that is required by SwiftMud, the city code, and, any other municipal codes that we're required to comply with. Let's see. I'm not sure if it's beneficial, but the difference in these setbacks, we're about 10 feet further back from the Gulf of Mexico. We're about 50, I think it's 55 foot 6 inches further from Gulf Boulevard with our front and rear setbacks. So we've increased dramatically those setbacks, and the side setbacks are pretty close, within about 2 feet of what's approved and what's proposed. The northern setback is identical to what was originally proposed. And on that northern setback, we originally agreed to provide the city and its citizens an egress easement to the beach, and in doing that, we were to pave with brick pavers 5 feet of that 10 foot easement, and we've subsequently agreed now to pave with pavers the entire 10-foot wide easement all the way back to the beach in order to assist the city and emergency personnel in accessing the beach if there's someone out there that needs their assistance, as opposed to having to walk or go all the way down. The emergency people don't have to walk down there. They can take a vehicle or a gator or something like that out there and prevent somebody from having to bounce along on a gurney or put anybody in jeopardy time-wise. Let's see. There was initially a bus stop that was proposed, and it has been eliminated from the site plan. My understanding is the bus authority didn't want us to do that, so we're not going to provide that. There was a gentleman that had suggested that in prior meetings that there might be a Panera's built there, and I'm not sure where that idea came from in those commercial buildings, but it's not zoned for restaurant. It's ROR, and so we can build offices there, basically. I'm told that the separation agreement is in good order and properly done, and been recorded properly and timely, and so the separation agreement was questioned at some point with regard to ownership of the two units, and my investigation has indicated that that's the case. Is it has been separated properly and ownership is properly exists today. There in the separation agreement, the parking is shared. Originally, there was an owner that was concerned about views from Unit 804 and in Building A, and I owned that unit for a good while, and unfortunately sold it for less than I originally paid for it, and the customer that's here today is the one that purchased it from us, or had voiced his concerns concerning that. So I personally know that unit and know each of those balconies. I've been on them. I've been on almost all of them in that building. Being the contractor originally of that building, I was there almost daily for over a year. And so my opinion is that increasing the setback on the building to the north of us in the way that it's been designed would do nothing but increase the view corridor and, in my opinion, increase the potential for the value of that unit and the units that are on that northern side. I've got a, I think there was some concern with regard to when the owners next door had knowledge of this building coming into fruition. And I have a a timeline of events that I would like to introduce into evidence, if I could, that kind of explains how things occurred and when they occurred. I think this one I've got enough for everybody. The 8th day of the 7th month of 2004, we received a building permit for La Vistana A, the large 40-unit building to the south of this property. On the 27th day of the 3rd month of 2006, we received a building permit for La Vistana 2 or B, the building to the north within the condominium association. We immediately started installing the pilings on that piece of property and began to construct a 14-unit building, 8-story, 7 floors over parking condominium. That approved building, through my understanding, could be built as it is approved today. And Mr. Miller prefers not to go that direction. He prefers to construct a smaller building, increasing the setbacks to help with his agreements with his neighbors, and also he feels it's better for the project and all around. On the 3rd day on the 7th month of 2006, La Vistana 1 was issued a certificate of occupancy. And at that time, closings began with buyers of those units. On the 8th day of the 3rd month of 2007, Fred and Deanna Goad purchased Unit 504 in Building A. On January, or the 1st month, 15th day of 2008, Anthony J. and Teresa Giampetro purchased Unit A804. And the reason I bring that to your attention is I have a set of the condominium documents that were originally filed with the state of Florida and was a part of, I would like to make that timeline a part of the evidence of our proceedings if I can.
We'll accept that as
Mark that A7.
Okay. And the reason I bring that point up is these are the condominium documents, and I'd like to make these a part of evidence as well. And in these condominium,
Condo docs.
condo.
and in these condominium documents, we have a site plan, and everyone that was a part of this condominium agreed to abide by these rules and regs, and part of that are the site plan and unit designs. And just to show you that everybody, and y'all can keep this, but this shows that those buildings projected out the way that we say they are approved today. And that they were all aware of that if they were to take time to look through those documents and understand them. I talked about the views from Unit 504 and previously when we looked at our view corridors and our elevations and site plan. My understanding is that the homeowners association supports of La Vistana A or 1 through their 80% vote to separate and agree to utilize together the amenities of that exist today, the swimming pool and the spas, and also of the bath on the Gulf side, and of the additional parking that they've all agreed to utilize through that separation agreement. My understanding is that they support the new site plan and request for the PUD amendment. That's been through discussion with board members of La Vistana A. I think that's about it, and unless y'all have any questions for me.
I only have one. Do you know when that vote was taken?
I don't, but I believe there's someone here that can answer that question. I've heard 9 months ago. Okay. Thank you.
No questions?
No question.
Mr. Lyons, any questions?
Okay, thank you.
All right, anyone opposing that wishes to speak?
Evening, gentlemen. How we doing?
Good. Need to state your name.
Kevin Carino. I'm appearing on behalf of Anthony and Terry Giampetro, residents in Vistana 1, Unit 804. And my business address is 3001 Executive Drive, Suite 335, Clearwater, Florida 33762. I would call the Commission's attention to Florida Statute Section 163.3231, which provides that a development agreement shall be consistent with the local government's comprehensive plan and land development regulations. That's not ambiguous, that's not subject to interpretation, and it certainly doesn't say that it may be overlooked in the event of creation of a PUD. In fact, the town's own ordinance with respect to a PUD provides that, and this would be section 90-104, paren E, paren 5, paren little case a, paren 2, referring specifically to a planned unit development, that buildings or portions thereof located more than 100 feet from the Gulf Boulevard right-of-way shall not exceed 85 feet in height as measured from the crown of the adjoining road. It doesn't provide for any exception to that. That is the town's comprehensive plan and building code. That development agreement must comply with that comprehensive plan and building code in order to be legally valid under the statute. Town of Reddington Shores Code Section 90-92 provides that to exceed that 85-foot height limitation requires a variance. The code provides very clearly that a modification of the regulations issued pursuant to the town's building code, when a variance is not contrary to the public interest and when, owing to conditions peculiar to the property and not the result of the actions of the applicant, a literal enforcement would result in unnecessary and undue hardship. That is the standard under the town's code. That is the standard under state law. Now, undue hardship is not something of the builder's own creation. And as you just heard Mr. Lyons testified, the builder is more than happy to stick with the original plan and the original height of 85 feet. So he certainly can't claim at this point that there's any hardship. Furthermore, with respect to the condo documents, which Mr. Lyons referred to, as somehow or other creating a contract with the residents of La Vistana 1 with respect to the construction of that second building and whether that would alter their view. That contract, as represented by Mr. Lyons, provides that that building will not exceed 85 feet. So our position is very clear that the ordinance cannot be passed. It's inconsistent with Florida statute. It is inconsistent with the town's own building code and its own ordinance. The remedy for my client, in the event that the ordinance is passed, he is entitled to seek injunctive relief to prevent any action under that ordinance, which he clearly intends to do, and that is his right. Now, we would ask that the town reconsider its earlier passage of the ordinance, because we also believe, and I think the evidence is going to show, that the developer failed to properly separate the second parcel. Therefore, there are questions about who legally owns that parcel. And I think there's going to be ample evidence introduced if the ordinance is passed to establish that the developer doesn't own that property, not under the current statute and the way the property was separated. So we would ask that the commission consider all the evidence, its obligations under Florida statute, and application of its own building code and town ordinance in denying the application for the development agreement.
Would you say again who you represent, what unit they're in, wherever?
Anthony Giampetro and Terry Giampetro, Unit 804.
Are they here tonight?
They are not.
And if I could, you mentioned something about you believe that the developer, the applicant may not own the property or whatever, and that you anticipate evidence. Do you have any evidence to that effect here tonight?
I'll let Mr. Ross address the issues concerning legal ownership of the property and the separation, but it's our belief that there's ample evidence that the developer does not currently own that property.
I'm not sure that's necessarily before the town commission right now, but if you had any evidence, wanted to make sure they heard it.
Sure. But certainly under the statute, this development agreement does not comply with the requirements of the statute. And a variance cannot be granted because there is no undue hardship to the developer, as we heard in testimony this evening.
Is it your clients, it's your position that your clients would rather have the building that was previously proposed rather than the one that's proposed now?
It's my client's position that the town needs to abide by its code, its building code, and will limit the height to 85 feet, which is what the original plan submitted was. That this development agreement, providing for a variance, which is not approved under the requirements of the statute, cannot be signed and would not be legal. Now, if the developer wants to come back with another plan, that's up to him. But this plan will not comply with the requirements of the statute.
Okay, thanks.
Thank you. Yes, sir.
Good evening. My name is Robert Seitz. I live at 317 Fremantle Way, Reddington Shores, Florida. I am the president of the Condominium Owners Association for La Vistagna A. I have sat by and watched this development happen when the potential buyer stepped forward with a number of benefits, and I mean, you heard Mr. Lyons demonstrate the benefits to the building, and yet I see no setbacks because we were all quite aware of Building B or Building 2 was going to be built when we originally purchased into Building A. In fact, if you were observant, the pilings were in the ground, which outlined the building, and to go from a building of 7,000 square feet to one of maybe 4,000 per floor, to reduce from 14 people there with common usage of the pools to 7, to increase our parking, to put a bathroom on the first floor, to take away that fence in between us and landscape all the property. The facts are, we hired the condominium's attorney was contacted. None of us are attorneys. And we said, per Florida state law, what do we need to do? He prepared documents, and he said, you have to go out and get at least 80% of everybody who's on the covenants right now to concur with this. He prepared the documents. They were provided to Condo Management Plus, our management company, who distributed them to all the people. They came back in, they brought them in, they looked at them. They then provided them to the lawyer, who then scrutinized very carefully all the documents. And we had to go back out, the condo, and get some of them corrected. Not that the people didn't agree, but there's a lot of legalese that go into any kind of a document of any such nature. When we reached the 80% point, the gentleman who was representing us in law suggested we file these with the state after providing, I think it's 60 or 90 days, I'm not a lawyer, time for anybody who objected to the division of the buildings and to the things that they knew were going to happen to come up with any kind of a written or even a verbal comment back to him, back to the management company, back to me as the president. We received none. So we received over 80% yeses. We received nothing in writing back that said no. And so the developer proceeded ahead with this joint separation. I think it's, at least if the lawyers who represent this type of operation in this county are well qualified, and I think that's what we hired, this thing is solid. And we, after 5 or 6 years, would like to get on. That's been an eyesore. We've had all kinds of problems with it. And we just think a building there would really enhance both our communities, would enhance the city, the green belt we really want, because that, I think, will enhance all of us. So believe me, we have done everything we could per the letter of the law to get this done. And I'm very surprised at this late date that all of a sudden we have all of these objections. I hadn't heard any of them before.
Do you remember when the 80%?
We went out way before the first of the year. But then slowly but surely, the things started coming in. And then we had this, this deadband where we had people who wanted to reject in writing. The answer is, I'm not sure, but we've been working on this well over a year. And it's been announced to all the people. As you're well aware of, you've got a percentage of people who won't open their mail, who live in Canada, who live overseas, who wouldn't vote anything. The other thing that's of great importance, we came up with a good settlement for Wells Fargo when this whole deal went down. They provided us over $200,000 as a settlement agreement for common area fees that they had not paid when they owned the land. I think Wachovia owned it to start with, but that's immaterial. For the last 8 months, I, as president, with my board members, have allocated these funds such that none of the 40 owners that live in Building A have paid 1 penny of common area fees. Do you know I didn't get one complaint? I can't imagine why.
Question.
Yeah.
Is this going to be turned into one association?
Two.
You're going to have two separate associations?
Because there's a real interesting rule. We have long-term maintenance. The buildings are, you know what I'm saying. There's things, now we have a lot of general things, like the general usage of the pool, the jacuzzi, the entrance gates, the landscaping that's on, that we have figured out a way, and it's in the agreement, that we'll share the expenses for these. So long-term wise, what La Vistani has been paying totally for will be a shared expense in the future. So it's beneficial to them as well.
Who was the condominium attorney?
Bob Tankel.
Okay.
And I'm sorry, earlier you gave your address. I wasn't familiar with the street. Maybe that's a.
Oh, right across the street, the new development, Reddington Yacht and Tennis Club. That's one of the new streets in there. And we actually were the original purchaser of Unit 501, and we lived there for a year plus while our house was being built across the street. So we know the building well.
Currently own a unit in La Vistana 1.
501. Can I answer any of the questions from a different point of view?
Any questions?
Thank you very much.
Very much.
Thank you.
Yes, sir.
I'm opposed. I don't know, that didn't sound like you were in the opposition. So I guess we're bouncing up and back. Good evening. My name's Howard Ross. I am an attorney.
Wait, or would you rather go down?
I'd rather go now.
Okay.
Yeah. I'm Howard Ross, an attorney at law. I represent the GODS 504, Unit 504. And I spoke to you last time also. Before I start, I know I don't have to do this, but I'd like to compliment your staff. I've been out here twice in the last couple of weeks. They've been very courteous, very professional, and they do a nice job. And I'm sure they could use another compliment every now and then.
We give them to them.
You're right.
Not too much.
Okay, well, sometimes it's nice to hear it from someone else, especially since I might be the opposition. I just have a couple of responses. Somebody said nobody said no to this. My client said no. I have the email where they said no. I would, to answer your question, we're taught to answer questions when we can, when they come from the bench. The plan of partial termination of La Vistana condominium is dated January 7th, 2013. The consents, which Mr. Denhart has, I sent that to you, and I would like those to be part of the evidence. I sent you this letter that went from Mr. Tankel to the Department of Business Regulation, which is part of the termination provision, and it has all the consents attached to it. They're dated various times, but at the end of last year. I also sent to, and I'm going to go out of order in my little speech, to Mr. Denhart. I'd like that to go in evidence. The property appraisers listings for several of the units. The consents are defective. There's enough consents that are defective that they did not get 80%. There are 6 consents where the units are owned by a recognized Florida business entity, and that business entity did not sign the consent. The consent were signed by individual. Every single consent is signed by an individual. 6 of those units are not owned by individuals. There are 2 of those consents that the person who signed it did not own or does not own the unit that he signed for. He may own another unit, but he does not own the unit he signed for. So that's 8 of the consents that are not good. There's 1 consent that the property is owned by a husband and wife, and only the husband signed. I don't know if the wife passed away or not, but the consent just has a blank there. So the consents, the votes, the other problem with the consents is Redus, R-E-D-U-S, who was I guess it's the Wells Fargo subsidiary that owned the property, probably bought it in at mortgage foreclosure. They voted 14 units in the B building, which do not exist. And they're in the condo docs, there's no elevations. Those units in the B building are not designated, are not described, so they don't exist legally. You can't convey those units because they don't exist. You can't convey a condo unit until there's a survey of record with the elevations shown. That's just a matter of law. In order to get to the condominium law, which would allow you to sell something that's 80 feet up in the air or 40 feet or 20 feet, anything off the ground, they had to come up with the survey must show the elevation. That's what allows legally to sell something that's up in the air. Redus didn't have anything because when they did the original condominium, they didn't have that building done. All they did was the A building, and it's got all the elevations, so you can convey out A. You just can't convey out B. So they got 14 votes that don't exist. At best, and I don't even know they have 1 vote, but at best they'd have 1 vote. But when you do the math, it doesn't work. They have 31 units signed these consents, forgetting for a moment the ones that I don't think count because they're not properly signed. Then you've got the 14 units that don't exist. 9 units in the A building did not sign a consent. The numbers as I make them up, if you take the 40 units in A, and if you give them 1 unit for all the rest of that stuff, that's 42. My math comes up that they need 34 votes to get 80%, and they had 32 votes. So math doesn't work when you throw out the consents that aren't proper. And while I'm speaking about the consents, that was rigged. They sent out consents that only said yes. They didn't give anybody a chance to say no in the paperwork. It's sort of like when you get a proxy from a public company or something like that, and it only gives you one choice. So I think that's another defect in this process. This statute is not relatively new, but it's been untested. I only found one case when I tried to look and see if this statute that allows the separation, if it's been tested in court. I only found one case, and it was, at least when I read it, I didn't feel it was relevant to anything we're talking about here. So we're in a difficult area as to what it takes to follow this statute and what it doesn't take to follow the statute. But the math and the units, that's in writing. And you can see unit so-and-so is owned by an LLC, and then someone else signs for it, not an LLC. And also,
You and your client engaged in any litigation with the association at this time on that matter?
not yet.
Okay.
So I take issue with Mr. Lyons, with all due respect, that this separation was done properly. I don't think it was done properly. You have the question of the 14 units that don't exist. How do you vote a unit that doesn't exist? You've got the ones that don't count. The other thing, another thing that Mr. Lyons mentioned, that somebody said something about they may not own it. Well, I think they don't own it. The warranty deed, or the deed, I'm not sure it's a warranty deed, from Redus, and I'm mispronouncing that, to La Vistiana to LLC, gave them 14 units, the B units, all the B units that don't exist, and the 2 parcels, which were common elements under the original condominium. They're in the site plan, and you just got the condo docs. And in the site plan, the condo docs are those 2 pieces. And the condo docs say that condominium property is everything that's not a unit. Well, it is everything. Common elements is everything that's not in a unit. So those 2 parcels, which you're supposed to get and have for your use, they may not own because they were common elements initially. So let me back up. When they took title, which was before the separation was complete, and I've got the deed in my briefcase, but it's before the title into La Vistiana 2, to these units. They didn't get this land. They got 14 units that don't exist and that you can't convey. So that's if nothing else, it's a question of whether they own the land. If they don't own the land, they're not entitled to get anything from you, whether it's an amendment to a PUD or a variance or whatever you want to call it. They have no right to get to that. The other problem is the way they voted. Redus votes for this thing, whether they were entitled to or not. Then when you get to the date of this separation agreement, they don't own anything anymore. They conveyed it away. And we don't have a consent from La Vistiana 2 LLC. So that's yet another problem with this separation. And we're in a very technical legal area with title to real estate, and it has some own quirks in the law. And dotting I's and crossing T's may be more important in that area than some of the others. So I would like to, and without repeating, just incorporate the variance argument that was made before. I don't need to make that again. I think I'll just go through this. I think I've probably hit most of my points. I mentioned this. Okay, the next thing. There's 2 ways you can separate in a condominium. You can separate or terminate as to part or all of a condominium if there's an economic need, if it's economically necessary. Then there's an optional one where it doesn't have to be necessary, you just want to do it. They separated, and it's in those documents I sent you, in that letter, because of economic need. And obsolescence, I think, is in there. But anyway, it was, the part of the statute they chose to follow was because economically they couldn't build it. Well, you heard 2 weeks ago, and again today, that building can be built, and he's willing to build it, so where's the economic obsolescence or the need? There's a building that can be built. So if it can be built, then that separation is based on something that's incorrect. I could use stronger language, but I don't see any need to do that. There was no need to use that, and they can't qualify under the optional one, because the optional one, in addition to have 80% for, you can have no less than 10% less, and we've got 9 units that didn't vote. Now, I write, I think I've mentioned, you're going to get 2 parcels of land, and I'm questioning whether you're going to get them. I don't know if the title insurance company does their job right. The title insurance, well, that brings up something else. You're not getting title insurance on the ownership of those 2 lots. When I read the development agreement, you're getting title insurance on the easement, and no title insurance on these 2 lots you're getting. And I don't know if that's what you intended or that's what you wanted, but I think you should get title insurance on those 2 lots. If you're going to own them, you ought to know that you own them. Now, another thing is the condominium documents, which you now have section 19, paragraph 19 is the termination provision. And it says, after termination of a condominium, which they did, any owner can bring an action to partition the land as an owner in common. Legalese, and he can correct me if I'm wrong, that's their tenants in common in whatever wasn't a unit. So now they've terminated. So that means, according to the condominium documents, the declaration, there's a tenancy in common. There may be 40 owners of the 2 lots you're supposed to get, and you've only got to deal with 1. There may be 41 if you count them. Even if you want to count their 7 units, now there could be 47 owners of those 2 lots, and only 1 has agreed to give it to you or to do anything else in connection here. All this parking they like to talk about, and I've seen a shared agreement. It's certainly not an agreement I would prepare for 2 condominiums to share parking. I didn't see anything about payment for repaving, which will have to happen every so often. I'm sure you're going to require them to keep the parking lots in good shape. And I think they're going to have to go back to the association, which could be other problems that aren't your problems. Then today, I was out here today looking at some stuff, and one of the things I looked at was the agreement that's you're going to sign, I guess, when they bring in all the stuff that they're supposed to sign, if you vote for it. A development agreement, and it had attached to it a drawing that says new legal description. It's not that. It's what's buried in the bottom over here. I don't offend anybody by moving this up. This says revised legal 9/24/13, which I believe was yesterday. So this is like a bowl of jelly. Everything keeps moving. That's part of what I complained about before is I can't look at what we're getting. This is different. They cut off a corner here. It could be good, it could be bad, but it's changing. That's not cut off here. So right now, I'm not sure what they're asking you to approve. What was handed out tonight is a different picture. This is in your record. So on this issue, I'm sort of in doubt as to what it is. But things are changing constantly, and I don't think that's fair to the community that they're coming in and asking you to do stuff, and then they keep changing it and moving it around. And nothing was said about that change, that corner deal.
What corner are you talking about?
I don't know, let's see, north, it'd be the southwest corner of the building. On this thing, which is actually an old drawing. This is a drawing from 2011, but someone has said revised legal 9/24/13, and then they have a legal description here, and I'm assuming that's legal. I didn't do I didn't trace the meets and bounds, but it has meets and bounds, which this one doesn't have. So it comes down here, it's sort of like, I don't know what you want to call it, it's a thin piece, and then it comes over here, and then it makes this jog, north 27 degrees, 58 minutes, 28 seconds, west 15.34 feet. And then this one is an absolute square.
So you're talking about the southwest corner of the new lot?
New building, yeah,
Okay.
which they're asking you to approve. This is, what I looked at today, this is Exhibit A to the development agreement. So, and like you said, what difference does that make to the city? But I think it does, or the town, because if they don't own it, they don't have good title. First place, they can't give you good title to what you're supposed to get as partial consideration for what the,
What difference does that make to the county?
well, I'm sorry.
I certainly didn't mean to say that.
Well, I'm paraphrasing.
I just was trying to get clear where you talked about a corner. I just was
Oh,
trying to
yeah,
get clear what
no,
corner
excuse
you're
me.
talking about.
With someone else, you seem to question when we fight, I think when Kevin said something about these questioning the ownership of the units. I'll take back what I said. You questioned him on what relevance it has to these proceedings. That's also a paraphrase. You probably said it a lot better than I did. But that's it. They have to, you can give owners of property some help and some stuff, but I don't think you can give non-owners any rights or to do anything. If you just give me a second, I think. They'd like to talk about this money that the owners did not have to pay their maintenance. It sounds like Wells Fargo, all they did was pay what they owed. They owned some land, they owned some units. Legally, they're responsible to pay their share of the maintenance. They didn't pay it. So they came up with settlement, yeah, you pay me what you owe me. Wells Fargo, I think, is solvent, and at the time this was going on, who knows? But at least today they're solvent. Maybe I shouldn't even say that. But anyway, so all they did,
Building is your office in?
Wells Fargo, they're our landlord.
Just one second.
So I'll strike all that. So that's my position. I didn't say a word about the buildings or what. I'm talking about the procedure and what you have to do, and what's been doing, and it's just not fair. It doesn't seem like what's going on is fair to either the city or the town or the owners. Keep changing things, moving them around. And doing this thing improperly. Just to preserve the record from last time, the amended notice of the first reading was not timely. It was 3 days before the hearing date. And the publication of the first meeting because of that day of the week error. And that's still out there. And then the other arguments I made last time was that time when I came out for the first meeting, the development agreement I didn't have all the parts to it. I've seen more of it now, although I'm wondering if what I saw is what it is because of that thing, which is, even on tonight's agenda, that's not what's on today's agenda. So I'm not sure what I looked at today, but it's different. So I thank you for your time.
You're not contending that your clients didn't have notice of the meeting 2 weeks ago that you were at, are you?
No, they didn't notice it was just late. I mean, yeah, obviously, I'm not going to take the chance of not showing up just because it was late.
Do you have a copy of the proxies that was used at that meeting?
Mr. Denhart does. I sent you something. I mean, I have some. I'll give you mine. In fact, why don't I just do this?
Frankly, I'm not sure what I have.
Okay.
What I don't have, and I don't have any of that with me, so
Okay.
please don't rely upon me introducing
All right,
anything.
let me just, if you give me
I'd
a,
like to see a copy of that proxy.
if you let me pull off my little notes to myself. And then, may I approach? They're in here. There's a whole bunch of them.
I'll give them back to you.
You can just keep that, I have that electronically, so you keep it. Okay,
Are your clocks here tonight?
no. I don't know what you want to call the opponent's exhibits, but you can make that an exhibit instead of,
Some names.
on the record, what you can call the opponents.
Well, let's call it, your clients are the goats,
Yes,
so let's call that goat number one.
okay, I'll make a note of that.
You accept this?
I accept.
Letter 2. And if you want to see the deed, I have that, I can dig that out. Or if you would like to see the property appraiser's printouts, I could give you those too, if you, rather than accept my representation.
Obviously, if y'all have ownership problems, that's gonna be something that's gonna be challenged in court between you and whoever owns.
But what I'm saying is, I think that affects the ability of the town to pass this ordinance, because it's passing an ordinance for someone that doesn't own the property.
Why have, well, I don't wanna be cross-examining yet, but
Well, you
nothing's been
can.
litigated on that so far.
No. No, this thing is started, and part of, well, my clients are some of those that don't live here, and the communication system that's set up for people that are living here doesn't work so well once you get our guests from up north. Okay, thank you very much.
Thank you. Anyone else?
There was somebody else or two that got sworn. Did anybody else want to say anything one way or the other? I'll say something.
My name's Mark Daly. I live at La Vistanda, number 200. I'm also on the board. I was involved with a lot of the meetings, all the meetings, actually, with all the homeowners, anybody who cared to come. And everybody was pretty much for this thing. It boils down to you have two people who live on that side of the building who don't like to see their view changed. The view in all of our minds is less encumbered now than it will be, than it was. And probably in one case, the objection didn't happen until after they couldn't buy the penthouse in the new building. I mean, I appreciate that they have counselors, they're doing their job, but they can drag this thing out until everybody's cross-eyed and tongue-tied. But I think we can get on with it.
Okay.
That's it.
Thank you. Anyone else?
Mr. Lyons has an opportunity for a rebuttal if he wants any. You don't have to take it.
Yeah, I'd like to. I have, for the last 20 years, been developing condominiums up and down the beaches of Pinellas County. And in each one of those, I've been involved at length and very deeply into the condominium document process. I'm not an attorney, but I've hired many of them and spent lots of time with them and been educated through actually going and doing it, and it being challenged at times, and understanding what's good and what's bad and what works and what doesn't. And one of the challenges of this property and the separation of this property and of the foreclosure of this property was that there was no meets and bounds area that existed with regard to those second 14 units. I agree with Mr. Ross that there were 14 units there, but I disagree with him. Those 14 units do exist in law. And if you look at the condominium documents that I submitted as evidence, it does have elevations and it does have floor plans. And the reason that Wells Fargo could not foreclose on a piece of dirt is because all it had was the right in law to foreclose on those 14 units. And when they did foreclose on those 14 units, there were two options that they had: to either develop that property, which they're not in the business of doing, or try and sell them away. In order to sell and obtain some value out of what they owned at that point in time, they determined, as well as the purchaser, that it had to be separated. And the document here is not the shape of the buildings. It's the shape of the land that was separated away through the agreement with the association. So the corner there is clipped off, but it's not clipped off the corner of the building. It's clipped off the legal description of the dirt that that building is going to sit on. My understanding is that they did have the right to vote those 14 units because they exist in law and they exist in those condominium documents. And there was no other way for them to be able to voice their opinion with regard to the value that they had. The two lots on the road never were a part of the condominium. They haven't been from the beginning. If you look at the condominium documents and the layout of the ownership associated with the association, they were not. So arguments concerning the lots not being able to be conveyed properly cannot stand up because they were foreclosed on separately from the association. The units were separate, were foreclosed on. The lots were actually foreclosed on as pieces of dirt with legal descriptions. I wasn't a part of the agreement to separate, but I believe the document talked, Attorney Ross talked about economic need is required. There's two ways to do it, economic need or obsolescence. And I don't believe economic need, as he alluded, was the requirement of Jeffrey Miller. It was, at that point in time, the association was determining whether they wanted to separate or not. It wasn't Jeffrey's point to determine if it should be separated. It was an economic need by the association not to continue to have to maintain that property. They are not in the business of development. And so I believe there was an economic need for them. And with regard to Wells Fargo having to pay back fees, I assume that they wouldn't be paying back fees on units that didn't exist. I don't believe that the law would require you to pay fees on units that didn't exist. And I believe the amount of money that they paid was not actually what they owed, because the state law talks about condominium documents and the budgets of condominium documents alluding to actual cost. You cannot make a profit being a condominium association. You're only allowed to do things that support the association. So if you have a water bill associated with 40 units, you really can't collect money for 54 units, but I believe that's what happened. And you're not supposed to collect money for an elevator maintenance fee when an elevator doesn't exist, or house power when it doesn't exist, or maintenance of the grounds, or reserve money for paint and roof and all those kind of things. But that's what occurred, and the money that they collected is a great benefit to them because it wasn't associated with all those fees. I think they really made a wonderful deal for the association. They did a good job with the bank. I think that's it.
May I look at the condo docs that he put in evidence, because they're different from mine, from what he's saying. I would like to look and see, I may not have the right documents, well, mine are the recorded documents.
They're in evidence, they're public records, and certainly you can see them after the meeting.
Okay, because I think he made a misstatement. There are no elevations for the B building in the condo docs that are recorded in Pinellas County. There are elevations for the A building. And that's the very significant
Okay,
difference.
Mr. Ross,
Okay.
I understand what you're saying. You had your turn. This is a rebuttal. You're certainly entitled to see these. They're in evidence.
Okay, I'll
And
look
they're
at
public
them.
records, and you're certainly entitled to see them after the meeting.
Anyone else? Hearing none, I'd like to close the public hearing, and if there's a motion.
I'd like to make a motion as follows. Based on the testimony and evidence presented, I move that the Town Commission make a detailed finding of facts as follows. That on July the 8th, 2004, building permits were issued on the existing building at 17720 Gulf Boulevard, Runington Shores, Florida, known as La Vista. 2, that on March 27, 05, ordinance number 05-05 was enacted, which rezoned both parcels at 17720 and 11730 Gulf Boulevard from RN-15 to Plan Unit Development, which also adopted the primary development plan for parcels reflecting the existing Las Vista building and proposed La Vista 2. Building, which at that time was proposed to extend 10 feet further towards the Gulf of Mexico and approximately 55 feet further towards the Gulf Boulevard than the currently proposed La Vista 2 building. That on March 27, 06, building permits were issued for such proposed La Vista 2 building and sustained construction commenced, including the driving of the pilings for the building that was proposed at that time. That on July the 3rd, 06, a certificate of occupancy was issued for La Vista 1 building. That initially the 2 buildings were part of one condominium project. The declaration of the condominium documents provided to each purchaser of units in La Vista, I clearly showed that there was to be a second building constructed just north of the original building, which would somewhat block the view to the north of occupants of La Vista 1. On February 28, 07, Fred and Deanna Goad purchased units number A504. On January 11, 08, Anthony J. and Teresa Gampito purchased units A804 from an original and current developer, Robert Lyons. That all of the zoning to plan unit development approval of the conceptual site plan and development orders pertaining to the originally proposed larger La Vista 2 building were already in place prior to Gold's or Campito's purchase, their units in Las Vista. And I timed their purchase of such units. They were provided with condominium documents reflecting that there would be a building similar size, length, and their building built just north of their building of number 1. Initially, the purpose of Las Vista 2 building was to contain 14 residential units and its length running from east to west to be approximately 65 feet longer than the currently proposed building. That the currently proposed building is for 7 living units, a 50% reduction density, which is favored in coastal high hazardous environment. That since both buildings were originally permitted as a planned unit development project, interior setbacks were not acquired, and that the currently proposed separation between the 2 buildings is now even larger than what was originally proposed. That in addition to the variance of 7 feet in height for the new building is minor and insignificant and would not impede a airflow or safety concerns and would not block any view of any occupants of La Vista 1 toward the Gulf of Mexico or the Sandy Beach area or north of Gulf Boulevard or east across the intercoastal waterways. In fact, with the new proposed La Vista 2 building being set back 10 feet further from the Gulf, the occupants of Las Vista 1, as well as the properties to the north of Gulf of Mexico and the vista views up and down the beach will be increased rather than decreased. Can't get my breath. With nearly constructed La Vista 2 buildings being set back an additional 55 feet approximately from Gulf Boulevard from what originally permitted, with there only being open parking with that area. The views of the residents of the existing Las Vista Building 1 to the north and to east will be greatly improved over what originally permitted. That the 7-foot variance in height is reasonable and more than justified by the other benefits received not only to the town of Runington Shores but to the surrounding adjacent property. Owners of the town commission has the ultimate authority as a granting variance, and that such variance complies with the criteria of the Runington Shores ordinance. That since the currently proposed La Vista 2 building is to be much less footprint than the originally proposed building and only to be 7 units versus the original approved 14. The currently proposed building will be much lesser impact to any property owners to the north, south, or opposed to what was previously authorized and for which construction has commenced. That the condominium association in Las Vista 1 is actually the continuous property owner to the south of the proposed Las Vista 2 building, and that such condominium association overwhelmingly voted for approval to be postponed project, and the matters between the original condominium association and the proposed condominium association, such as shared parking, ingress and egress easements, etc., has already been worked out between the two condominium associations. That 3 advertised public hearings have been held concerning the developer's agreement, the first being a hearing before the Town Planning and Zoning Commission held on August 21st, the second being as the first reading of the ordinance before the Town Commission on September 11th, the third being tonight, September the 25th, 2013. At second reading, the ordinance before the Town Commission, that the town has exceeded all requirements as to the notice and public hearing. Based on the above finding of fact, I further move that the Town Commission pass the ordinance number 13-05 on the second and final reading. Thank you.
I'll second.
Motion and a second, any discussion? Hearing none. Patty, call the roll.
Commissioner Capper?
Yes?
Vice Mayor Branch?
Yes.
Mayor Adams?
Yes. With that, this meeting is adjourned.